Judge Bert Richardson, and he is the incumbent on Place 3, Texas Court of Criminal Appeals. And with me is Del Fessenden, Bob Bagley, Larry Rogers, David Smith, James Byers, Pat Tibbs, and Dennis Tibbs. And Judge Richardson, as we discussed, if you would like to get us started with up to a 5-minute opening elevator speech, that'd be great. Appreciate you coming in.
Oh, it's my pleasure. My name is Bert Richardson. I'm from San Antonio, Texas. I am the incumbent judge on Place 3 of the Court of Criminal Appeals. I've been a judge since 1999. By way of background, prior to becoming a judge or even going to law school, I was raised in a military family. Have the benefit of living all over the world. Europe, South America, and then several states across the country. I attended Brigham Young University, got my undergraduate degree there, and attended St. Mary's Law School in San Antonio. I put myself through school with a variety of jobs, including bulletproofing cars, working on the yearbook and taking pictures, and working for a small upstart airline called Southwest Airlines in the early 80s, taking reservations and going to law school during the day and taking reservations at night.
Nice.
In my second year of law school, at the end of the second year, the DA's office hired interns to help out with the felony courts, and I applied for the job. I was bilingual at the time. They needed a Spanish speaker to handle some of their caseload. So I applied for the job, got the job there. And they had a policy, once you graduated from law school, as soon as you passed the bar, if you wanted to go to work for them, you could. So for the next over 11 years, I served as a state and federal prosecutor in San Antonio. I went from the DA's office to the U.S. Attorney's office, and then while I was at the U.S. Attorney's office, the legislature created new courts in Bexar County, and I was encouraged to apply. I was a little bit reluctant to get into the political arena. I'd always wanted to be a federal prosecutor and kind of brushed it off, but I was encouraged again. So just to get everybody off my back, I applied, sent my application to the governor's office. I was interviewed, and I was offered the job in 1999. For a district court bench. And so I served there until the end of 2008. I've had the pleasure of being elected and knowing what political sweeps are like in a county like Bexar County, where you just get beat because you're a Republican. And so at the end of 2008, I was defeated in that election. We call it the Obama sweeps. At that time, I was an adjunct law professor at St. Mary's, and I was vested in the judicial system, so I really was kind of at a crossroads on what to do, and I had kind of a window of a few months to make my decision. And so I don't know how familiar y'all are with the visiting judge circuit in the state of Texas, but the state's divided into 10 administrative regions, and if you had been elected for 2 elected terms and you were eligible to sit anywhere in the state of Texas, all you had to do was contact the regional presiding judge and give them your name, send them your resume, and then if they felt comfortable assigning you to cases, then they would do so. At the time, I thought I might be able to go back to the U.S. Attorney's office, but they had a hiring freeze. So I started visiting, and within about 6 months, I had a full plate of assignments. It became a full-time job for me for the next over 5 years, and I worked in 3 judicial administrative regions. I worked in 50 counties across the state. Reached a point where I was getting assignments. Usually a lot of the cases were just covering normal docket matters. Some of the cases assignments were case specific, so I would get cases that nobody else wanted. At the time, I was board certified in criminal law, and I had a substantial amount of experience both as a trial lawyer, prosecutor, and judge in handling some of the complex cases. So I was lucky to have a full-time job doing that. I worked all over the state. I've got to tell you, it was a fascinating experience, working in small towns, big towns, having complex cases. And then in 2014, 3 judges announced they were going to retire from the Court of Criminal Appeals. And I was encouraged to consider running. And I really didn't have anything to lose at that point, and I was told I wouldn't have an opponent. As it turned out, I had a primary opponent and a general election opponent. And I won the race in 2014, and I've been on the court since January 1st of 2015. So I enjoy what I do. I think I don't need to take any more time on my background.
Okay, well, thank you very much, appreciate that overview. If you would, explain, so you have 3 levels of judges in the state, and our Supreme Court, you guys are at the same level, but broken apart from the Supreme Court.
Is it okay to hand this out while you're talking?
Sure, sure.
It has on the back of it,
Okay.
on the other side, you can pass those around. One side has my qualifications and my opponents, the other side has the layout of the judicial system in the state. It was done by somebody who's not a lawyer, my wife, and all of those who are not lawyers really enjoy the chart. So just flip it over and it has all of the courts in the state.
Okay, so if you could just kind of briefly, in a couple minutes, give us the difference between what an appeals court does, which is kind of the tweener
Yes.
between trial court, and then what you guys do at the highest level of court of criminal appeals.
Sure. I think usually what you see on the news typically is the trial courts. It's witnesses who come and testify, juries who listen, juries who make decisions. Once those verdicts are reached, whoever loses in those cases, depending on the type of case, has a right to appeal their case. And those appeals go through the intermediate appellate courts on your chart right there. Everybody has a right to take those cases to the intermediate appellate courts, and those courts have to render opinions. Whoever loses at the intermediate appellate court can decide whether or not they want to appeal their case to either the Court of Criminal Appeals or the Texas Supreme Court. In plain language, what I tell people is the Supreme Court handles civil cases. Who gets the kids, who gets the money, who caused the wreck, what did the doctor do to you? At the Court of Criminal Appeals, we handle three types of cases. We review all death penalty cases, and those do not go to the intermediate appellate courts. We review last-minute appeals, last-minute writs. We review the original appeal, it comes directly to us, and then we decide whether or not the defendant should be executed, and then he can take his claims to federal court. We also review post-conviction and pretrial writs. Those are claims that defendants make on post-conviction writs that, hey, I got convicted, science has changed, there's new evidence floating out there that shows I really didn't do it. I want you to take a look at my case again. Michael Morton is probably the most famous case in the state of Texas under that claim. And then right in the middle are the normal types of appeals that we get that come from the intermediate appellate courts. They a lot of times deal with search and seizure, interpretation of statutes, any number of things, and those are discretionary. We don't have to take those. We just vote whether or not to grant review, and once we grant review on them, then we issue opinions on them. So those are the three types of cases we have. We do only criminal cases. The Texas Supreme Court does civil cases, and they don't tell us what to do, and we don't tell them what to do. Every now and then, we get something that kind of gets close to that line, but that's it.
Okay, great, yep.
Okay, you're one of 9 judges.
I
You
am.
hear all the cases. I'm gonna give you an interesting question here. Which of your 8 compadres do you identify with or agree with most? And please briefly give a couple of examples of why. And which one do you disagree with most? And give a couple of examples briefly.
Probably 2 who are closely aligned would be Hervey and Newell. And Hervey usually joins Kiesler. So, but usually Hervey and Newell, I think it's like any other job that you have friendships and things that are in common. I think they're pretty low key. They're tactful about their opinions. They're not in your face. They strive to do what I feel is the correct thing and follow the law as closely as they can, and their opinions are clear and concise and easy to read. They're not bombastic or in your face or anything like that. I think, the Court of Criminal Appeals, other than a couple judges on the court, has a pretty good reputation for being very conservative. I mean, in the past, we've been criticized for being overly conservative. Scott Walker is probably at the far end of the spectrum. He's probably the nicest to get along, but he comes from a strictly defense background. So he brings that perspective to the table. I'm not saying I always agree with it or not. But Newell and Hervey would be the ones I'm most closely aligned with. I worked with Barbara Hervey in the DA's office in the early 90s. David Newell I would describe as the kid brother on the court who's probably the genius on the court too. He's got a pretty good mind.
Okay. Larry?
We'll go to Bob, and then we'll go back to Larry and then go across.
You brought up visiting judges. What's your opinion on visiting judges?
I think they serve a good purpose, and I think the lawyers, the judges that appear in front of the lawyers, if it's a civil case, lawyers have a right to just object to a visiting judge right off the bat. So they don't like them, they're gone. It's like a strike. If they're not comfortable with the criminal judge, there's also ways to challenge them or anything like that. It's a good organization. The regional presiding judges appointed by the governor that assign judges across the state are some of the finest judges I've worked with across the board. I can't remember who's out here, but I worked with Judge Peoples, Judge Harrell, Judge Abels in West Texas.
Judge Underwood.
Yeah, Judge Underwood's over here. I didn't work in this region, so I know of him, but I've never worked with him. And I think they keep a short list of judges that they're comfortable with, that they assign, and that they think are competent and know what they're doing. The advantage of being a visiting judge, certainly in politically charged cases or cases where the locals don't want to do it, is we just call it R&R, rule and run. You come in, follow the law, do what you're supposed to, and there's no political or downside to ruling like you do. And sometimes in the smaller counties where I've worked, the judges just don't have the experience to deal with some of the cases you do in the big cities, death penalty cases, post-conviction writs. I did an actual innocence case in Fort Stockton. None of the judges out there wanted to touch that case with a 10-foot pole. It was just an evidentiary nightmare. So that's the advantage of having them.
What about judges that were elected and then were unelected?
Well, some of the regional...
They fall into visiting judges
They
as
can. Well, it depends. Some of the regional presiding judges in the past have had rules where if you lose in a certain county, then you can't sit in that county because you've been unelected. That was kind of a policy before 2008. After 2008, when they started seeing a lot of sweeps, then they started making exceptions to that because they realized they were losing good judges. I mean, you know, like on the appellate level, Brett Busby was a classic example of that. I mean, went to an Ivy League school, clerk of the Supreme Court, was on the Houston Court of Appeals, and he lost. He's now in the Supreme Court, but so I think they're very cautious about how they do that. I fell into that category in 2008, so I didn't sit in Bexar County for a while, but kind of at like 2011 or 2012, they were getting behind in death penalty post-conviction writ hearings. And my successor didn't know how to do them. A lot of the new judges didn't know how to do them, so they just asked me to come in and do them. So it's discretionary with those judges. I don't think they bring in judges that are a problem. They have total discretion on who they're going to bring in. There may be some disagreements on that, but at least the regional presiding judges I know,
Gotcha.
does that help?
Yeah, thank you.
Larry?
Your term limit is 4 years?
6 years for
6
appellate
years.
judges, 4 years for top court judges.
6 years. We've interviewed judges in the past, and one of the questions that I think we all, how in the world do you keep your bias out of a case? If you were a prosecutor or a defense attorney, I mean, how do you do that?
I would start by saying, number one, it's the oath that you take. And number two, sometimes I don't think judges are able to do that. I've worked with some. Since I've been a judge, I've usually had, I don't want to say bipartisan support, I've had support from defense lawyers and prosecutors throughout my career. I was in constant demand as a visiting judge. I think that the way you do that is by following the rule of law. And you be consistent in your rulings, and I tell people the easiest thing about being a judge is just being nice to people. Some judges are just not capable of doing that. I don't know why. It really is the easiest part of the judge, just being respectful to the litigants and then carefully following the law. And sometimes following the law is not the popular thing to do. And that's the way it goes. I'm mindful of that. I've been in those cases. It's not fun.
Yeah. You currently only have one that's running against you. Is the time limit over for filing, or is
No.
it possible
It's,
December 1?
it opens November 9th, and I think it closes December 9th or 10th.
Do you anticipate anybody else?
No, I don't know. No, it's too difficult to get the signatures. If somebody's gonna run against you, you would know about it by now. You would either cross paths with them in some of the forms where they have petition signing parties or something like that.
How many do you have to have again?
You have to get a minimum of 50 good signatures in each appellate court region in the state. There's 14 appellate court regions. Comfortably, you should get 100. You should get twice as many as you need, and then you have to verify that they're all registered voters, organize them, and then take them to the Republican Party and file. It's a difficult project. Not for Houston or San Antonio. Try going to South Texas or El Paso or just getting up into the Panhandle. It's not easy.
I take it you have yours.
I do. Yeah, I'm going to file this week. I have twice as many as I need.
Okay.
So, I was interested in your talk about visiting judges, so we have an experience with a visiting judge in Montgomery County with Toma. And, I guess that was a rule and run scenario.
Might have been.
So, why, we have a new Toma now,
Mhm.
right? And, but some of our state reps say that they're not sure it's gonna survive, survive a ruling.
Mm.
So why is it so difficult to write a law that, stands the test?
Specifically that law or just laws
Just that law,
in
yeah,
general?
yeah.
Well, I'm familiar with the case that you're talking about, and I think one of the difficult things you do, and I can't remember who the judge was in that case, to be honest with you, the trial judge. Sometimes, certainly in First Amendment cases, which seem to be subject to more review than any other types of cases, you have different standards. Is it the conduct that's being penalized or the speech that's being penalized? And once you decide it's a speech, then you have to analyze it under what we call a strict scrutiny standard. And is it clear? And I remember when that case came out, and I know the legislature immediately changed it. We have another case that's kind of on the burner right now related to First Amendment. We haven't issued the opinion, but the legislature has realized even before we issue our opinion, there's a problem with it, and they have amended the statute. A lot of the people who write the laws aren't legal experts, and I had to deal with that when I was assigned on a visiting case in Travis County several years ago. The language seemed clear, but when it went up to the appellate courts, I followed the law as a trial judge. The intermediate appellate court agreed with me, but when it got to the high court, well, they reversed it. They had the authority to do that. But that's probably why First Amendment claims under U.S. Supreme Court guidelines can be difficult to analyze. I don't know if that helps or not.
There was a visiting judge, y'all remember his name?
Yeah, they're unaccountable, that's the problem.
Yeah, I mean, there's some truth to that, and I think if, from either side, if there is some concern about their ability to preside over the case that they've been called on, either side has the opportunity to object to them or file a motion to recuse them. And if they previously lost a race, then either side can say, look, you lost, we don't have to take you, bring in the next judge. So that's kind of how the checks and balances of that work.
I never knew that.
Very few do.
John, I need you to crack the door. Not much.
I know, yeah. I'm cold.
You're
You're always cold. It'd be 100.
It's warm in here, but I'm in the hot seat, so.
Now, I know you don't want, well, when we've interviewed judges, there's a lot of things I don't want to comment on. So I'm going to give you a current case that's outside Texas state jurisdiction.
Okay.
And it's in the news. It deals with a military case that President Trump had to issue a pardon in order to provide justice. And some of the particulars are that you had a platoon, a lieutenant, Army lieutenant, platoon leader in the field, and they're on a road with known IED placements. And there were two Afghans on a motorcycle approaching. The Afghans ignored their warnings, and the platoon leader had to make a decision, and he ordered their being killed.
That was on the radio as I was driving up.
Good. Now, he, at the time, of course, had only what we just described. They'd had a prior incident where their platoon leader, former platoon leader, was actually injured in very similar circumstances. Well, then later, he was determined that was a violation of the rules of engagement. which at the time, those were bomb rules of engagement that basically you had to wait until you were fired upon or an explosion occurred. So they were prosecuting him for his decision, determining them to be a threat. Now, later, before the first trial, but later they did get they took DNA evidence that linked the two people on that motorcycle with prior IEDs that they had, that they had discovered. So, and that information was withheld from the defense. So now that's come up, and the prosecutors basically have said, well, they withheld it because they considered it non-exculpatory because the lieutenant didn't have that information at the time, you see.
That's not the standard.
Well, that's what I would think. So the people understand your way of thinking. In that situation, was that appropriate? If yes, why? If not, how do you deal with prosecutors that abuse the system like that?
2 minutes? Kidding me?
His question was 4 minutes, so you can take 4 minutes.
Yeah, sorry.
Well, the leading case in Texas and the United States is out of Williamson County, Texas, Michael Morton, where exculpatory evidence, Brady evidence was withheld.
Mm-hmm.
Michael Morton was accused of murdering his wife. He was indicted. He was convicted. He got a life sentence. I don't know how many of you have heard the story. It's an amazing and remarkable story of just because of the type of person he is. They zeroed in on him. There was very little evidence linking him to the murder of his wife, and off he went to prison with a life sentence out of Williamson County, which was regarded as one of the most conservative counties in the state. And he sat there for 20 years. Somewhere around the 20-year mark, new evidence came along, new science, DNA came along, and they started to petition the courts to test it. While he was in prison, they had told him repeatedly, because he became eligible for parole, if he just admitted he killed his wife, that they would parole him. Got his master's degree, he was a model inmate.
Huh.
Somewhere around the 20-year mark, he petitioned the state to test a bloody scarf that the family had turned over to law enforcement in the backyard. Fortunately, it stayed in the evidence room for all those years. The state fought it for 6 years. The DA at the time, he was prosecuted in 1988, went on to become a local judge. He was quite popular locally and in the state. The person who succeeded him was regarded as one of the most conservative DAs in the state. Just to get the scarf tested took 6 years of litigation, the Innocence Project being involved. When it was finally tested, it revealed his wife's DNA on the scarf and the DNA of a convicted felon who was on parole, who lived in the Bastrop area. If that wasn't enough, because Travis County and Williamson County border each other, they didn't share information. His DNA was in the CODA system, and what they discovered is a mile down the road there was a similar murder around the same time, same manner and means, with the same DNA of the defendant. Morton subsequently had what's called a post-conviction writ hearing. So when I talk about cases the court handles, we have death penalties, appeals, and writs. In that writ hearing, as what normally happens in actual innocence claims, is you start peeling back the onions and you learn that maybe evidence was withheld. In that particular case it was. His wife, he was at work, his wife was at home with their 3-year-old child. Their 3-year-old child had told the sheriff it was not his dad, it was a monster in the house with a beard. His wife's credit cards and checkbooks were used after he was arrested. And so Morton was subsequently exonerated. The judge who was a DA at the time was removed from the bench, he was disbarred. Statute of limitations had run on a lot of things they could charge him with, but he was subsequently charged for withholding evidence, got a felony conviction, spent a short period of time in jail. That's the first case in the country that I'm aware of where prosecutors have been
Prosecuted.
Yeah, taken to task on it. So I've been involved in more cases than I have time to talk about where the DA has withheld evidence under the idea that I get to decide whether it's Brady or not you.
Yeah.
The general rule of thumb in my world, at least, I prosecuted death penalty cases and everything else, was if I have to think about it, I just give it to them. Actually, in any case I had, I said, look, here's my file. You can come look at it. It's all there. I don't care what you see. If we're going to trial, you'll have the benefit of all of it, other than work notes that I've written to myself, and how to prepare trial. So it's, there was a pretty high-profile case out of the Houston area that had to get retried. His name was David Temple. He's a Katy football coach who was just recently retried and convicted. His conviction of 2007 was set aside because the prosecutor withheld 3,000 pages of police evidence, police reports, and then dumped them on him in trial. You know, it's just unfortunate. And people can be held accountable. How accountable they're held is in the eyes of the beholder and the person who went to prison for a long period of time. Morton's case is a remarkable story. He's a very humble person. He used his experience to better the system. He's still in his mid to late 50s. He's on the speaking circuit. There's a CNN special that they did now on Netflix called An Unreal Dream, where he's interviewed. It's a fascinating case. And when I teach my classes, I always make sure all the students watch that one.
Thank you.
Hope that helps.
Yes.
Randy Clapp, 169, was a visiting judge in the Toma case.
Okay, I don't know him.
Well, in that case you just described, is there any compensation for Morton?
Yes. In fact,
And
there
does
is.
the judge have some say in that, or
Yeah.
how's that?
You know, Texas, you have two ways of getting compensated. You can sue the state and hope you win the lottery, or the state has the best compensation package for wrongfully convicted inmates in the country. They get $80,000 a year for every year they've been in prison. They get a lifetime annuity that's equivalent to that $80,000. For example, Morton got like a $3 or $4 million check for the 25 years he was in prison. And then they take his expectant life term, and then they give him an annuity during that period just to make sure he doesn't blow all of his money at once. Those inmates or those exonerated individuals can attend any school in the state of Texas. They have free health benefits for the rest of their life as they were retired employees. It's a good compensation package. We've had 2 actual innocence cases that I've been involved in just this year, and I've been involved as a judge. I did one as a trial judge, and while I've been on the court, I've done 8 of those. And you know, the compensation packages have ranged anywhere from $1 million to $3 or $4 million.
In Texas?
Yes.
In other states, there's something similar?
It just varies. No, I don't think other states have quite what we have. A lot of times inmates or exonerated individuals have to resort to going to federal court and suing the state and then getting some sort of a settlement depending on why they were wrongfully convicted.
So have you worked with the Innocence Project?
I don't know, I don't work with them, but
Yeah.
I have had cases with them. Probably the last case I did as a visiting judge was in Fort Stockton, which is in the middle of nowhere. Like if you've been up there. I presided over a hearing where a lady had been convicted of pouring gasoline on her uncle and setting him on fire. She always maintained she hadn't done it. There was very little evidence for a motive or anything. She received a life sentence for her troubles, but was paroled after 8 years. She was convicted in '92. She was paroled in '99 or 2000 because at that time the arson experts across the country had decided that what they thought was an accelerant on these gas chromatographs was not. And so their testimony was wrong. And so I presided over that. I had to listen to evidence. I had to prepare findings of fact and conclusions of law that were submitted to the Court of Criminal Appeals. And then they have to agree that my recommendation is what should happen. And then the Innocence Project represented her. It was the first case in the country where arson evidence was recognized as being flawed in many cases.
Okay.
In that case, the uncle had a breathing problem. He had an oxygen tank next to him at all times. He would light his cigarettes with a blowtorch and cook his hot dogs while he was on a reclining chair. So that wasn't revealed either. So it's always interesting. I mean, you can't make it up.
So in your handout here, which we hope to either get up on US Vote Smart when we release it, or James can insert it here maybe magically.
I have a PDF I can send you.
Okay.
It's on his website too.
It is.
Okay, all right, great. Your experience as opposed to your opponent, is this by the way, is this a Republican opponent?
Yes.
In the
That's
primary,
my primary
okay.
opponent.
I figured so. Is quite a bit difference here. So what do you think really stands out as maybe the top 3 things of experience that you have versus your opponent that would put you over the top? And
I'm not sure where to start.
Where do you go? They're all
You know,
right here.
I am on the state high court. It is a difficult job, and we write legal opinions based on briefs that are submitted to us. We have to write opinions. We have to understand the law. We have to have had the experience in the field to understand the matters that come before us. I haven't really even met my opponent. She's been selling dental products for the last 27 years, but for all I know, that's what I'm told. I don't think, I mean, there's an easy way to find out how much appellate experience somebody has. I've verified that through her website and through Westlaw. She's written 3 appeals, and the last one was 27 years ago. She has no death penalty experience. She has no writ experience. I don't even know where to start on comparing the two of us. I've looked forward to getting into forums like this or being interviewed when people say, well, what are your qualifications and what makes you different? I have practiced criminal law full-time for 31 years. I've done just about every type of case that comes before my court. I'm comfortable with what I do, and I'm comfortable doing the right thing, and I think I put a quote in one of the answers when Neil Gorsuch was recently interviewed on Fox News. He said, you know what, sometimes the decisions we have to make we don't like, but that's what the law is, and we follow the law. Sometimes there's gray areas where we have to interpret what the law is, but a lot of times it's pretty black and white, and you're faced with making a decision that is not either politically popular or popular with one party or the other. And I don't like doing it, but I do it, and I'm qualified for this position. I don't think she is.
Okay. Fair enough. Deb?
Okay, I found your interesting on standards of behavior, your answer on standards of behavior interesting. You cited the Code of Judicial Conduct, and to Part C says, a judge shall not knowingly hold membership in any organization that practices discrimination prohibited by law. I'm going to give you a hypothetical situation and would like to get your response to this. Nationwide, there's quite a bit of effort to make identities, all that ideology accepted, law of the land, and so forth. If
When you say identities, are you talking about gender identities
Yes.
and those types of things? Okay.
Yes.
Right.
If the Freedom from Religion Foundation were to, if that were to go into effect in Texas, and Freedom from Religion Foundation were to approach you about the conflict, apparent conflict, or is there an apparent conflict between that and your church membership, how would you deal with that?
I'm not sure if I understand the question. Can you do a little bit?
Okay, well, the gender identity is acceptance of all of
Okay.
these things which
Yes.
are contrary to traditional church teachings.
Okay.
And so it would appear to me to be a conflict. May not be, because there may be other circumstances, but still, how could one deal with that?
If the government wants to intervene, or
Well,
specifically,
Freedom
I'm
from
not sure if
Religion Foundation, they always threaten lawsuit.
Right.
And so if that became the law in Texas, and they filed a complaint, a lawsuit, whatever,
And the complaint would be what?
that your beliefs are in conflict with the law on that, and so it says that you're not knowingly to hold membership in any organization that practices discrimination.
You know, the Constitution says there's a separation of church and state. I believe strongly in that. And religions have a special category of exercising their beliefs as they see fit in worshiping their own God. You know, throughout history, religions have been criticized for a variety of things. In my particular religion, maybe the simplest example would be I'm LDS, I don't drink. Just because that's my belief doesn't mean I impose those on you, but don't tell me that I'm doing something wrong by not doing that. And then if you want to be a member of my church, one of those standards is you're not going to drink, and we're not going to change that rule. And I view that under the Constitution is a separation of church and state, and we get to believe what we want to believe as a religion. Whether it's a club or something else, that's a whole different ballgame. I can't imagine in this current political climate in the state of Texas or with the U.S. Supreme Court that they would ever impose those type of restrictions on any religion. And my
It's
religion,
constantly entering into the
It
workplace,
is.
which of course your workplace is CCA.
yeah, it's entering into the workplace, but I'm not sure that there are any rules. I mean, I work with all types of people, however you want to categorize them.
Right.
You know, whatever their beliefs are. Those beliefs and that lifestyle does not cross into my workplace. It doesn't enter into my opinions, and when they leave the office, whatever they want to do is their business, but it doesn't factor into how I make decisions in the workplace and how I write my opinions.
And certainly I would expect that to be your answer. I'm saying if an outside person challenged that,
I would take it all the way to the Supreme Court. I just think it's blatantly wrong, and I think most recently when the favorite Democrat Beto said, if religions decide certain issues inconsistent with gender or sexual preference, and they don't, and they discriminate against them in any form or fashion, we're going to start taxing them. I just couldn't believe those words came out of his mouth, I'll be very honest with you. It was just, you can't do that. You know, you just can't.
okay.
There are moral standards that every religion has. Some are stricter than others. And I just don't think that the U.S. Constitution allows for that.
Okay, great.
I had a question until this one came up, so I'm just gonna follow on with this one. You brought up that you believe that it's written in the Constitution for the separation of church and state.
Mm-hmm.
To what extent? Because what is out there in the public today, in the media and in government, is not what the Constitution says.
Right,
The church is not going to control the government.
right.
Please explain to me your feelings about the separation of church and state and where one has the authority and the other one doesn't.
Well, I don't think the government has the right to come into your religion and then, one, tax it because you don't believe a certain way. Number two, impose certain moral conditions that are inconsistent with your religious values. And that would be the starting point for me. And if they attempt to do that, I think it becomes a constitutional challenge.
The biggest thing that we have now is that churches are not getting involved in politics because people keep quoting the separation of church and state. There's nothing in the Constitution that states that any church, any religion cannot be active in politics.
My church is involved in politics. I don't know about your church.
Mine
it's not a problem.
Mine is too.
Well, there's a
So I haven't
federal,
experienced that and haven't seen those challenges.
there's a federal law that is the basis for taking away the tax exempt status
Right.
if a church
54 Johnson.
does anything political. I forget the name of it. What's
It was the
Johnson
Johnson Amendment.
Yeah.
54.
It's never taken
Never
place,
been
but that was,
used.
Right.
but that's where I was coming from.
But yeah, a lot of preachers are afraid of that.
And that's what I wanted you to explain, because preachers really don't know, because they're scared from the media and from the government that they can't get involved, and that's leading to the moral decline of this nation.
Yeah.
Well, I mean, I think, you know, the LDS Church and the Catholic Church have had similar political issues that they've joined forces with in California, when California was trying to impose certain lifestyles and requirements or abortion bills and those types of things. My church has gotten involved in those. They have strong opinions on those. And I don't think the government has the right to take away our tax exempt status or punish us because we believe that those are God-given rights. And I would be comfortable going into court any day of the week over those issues.
Do you agree with the civil disobedience with regard to that, the Johnson Act? Right?
Well, yeah, but, you know, the civil disobedience just results in you getting arrested and you go to court and, you know, you challenge it, and if the rules are just totally ridiculous, then
you're out.
End of story.
Yeah.
You have to hire a lawyer, but.
Yeah.
Yeah.
Eat jail food for a while.
Right. Well, you get a bond.
Sheriff
They
has
don't, they don't keep you in jail for stuff like that.
You get a lawyer if you have money, and you get a bond if you have money.
Well, you know,
Yeah,
the,
that's true.
ask for a, if you get arrested for something like that, ask for a PR bond. They're gonna give it to you.
Judge, I meant to ask you this a while ago. Coming from a military background from your father and your brother, how did you manage to not be in the?
I was on my way to the Air Force Academy. My high school had 5 students who had nominations for the academy. I was one of 5, and I flunked my eye test. I had a lazy eye growing up. I had an Air Force doctor who gave me glasses to try to fool the test, and I soared through every physical and academic requirement that was necessary. And they had some machine that they looked into my eyes and said, "You've had eye surgery before, twice." And at the time, you had to be pilot qualified to get in the academy, and your vision had to be uncorrected and perfect.
Well, there was the
I was
Navy.
What's that?
There was the Navy.
My dad
They
told
take
me.
anything.
Yeah, my dad said, "You're not flying off an aircraft carrier. Go to BYU."
Smart day.
I had always wanted to be a pilot. I grew up around Air Force bases, and that was, so both of my brothers flew, and so I was a black sheep. I went to law school. Ruined my eyes.
James was Academy grad. That's
Naval.
He was
Naval,
Naval Academy.
Naval
Naval.
Academy, yeah, that's right. Not-
Well, I have 2 nephews that just graduated from flight school in the Navy, so.
Well, I tell
That's
my friend-
almost like
Yeah.
Royal Academy.
Dave,
My dad was pretty adamant about it. He said, "You're not flying off an aircraft carrier." I usually listened to him at that age.
no kidding.
You know, our district attorney, Brent Ligon, gave a presentation here one night, and he spoke about about over the last 4 years, let's say a 60% increase in felony filings in Montgomery County. That's
Family violence?
felony
Okay.
filings.
In this area?
In this area.
Wow. Okay.
And that's quite shocking when you
That's
think
a
about
lot.
it. Do you see that across Texas? Are we experiencing something that's
Well,
unique in Texas?
I was a prosecutor in San Antonio in the mid-90s, and it was a drive-by capital of the United States. So it's not as bad as it used to be in San Antonio, but I've always been mindful of the fact that the Harris County area had some pretty horrendous crimes. I mean, even working as a prosecutor, it's always going to be there. How it grows probably just comes with the population growth. I mean, this is kind of a booming area out here. I mean, it just seems to go on forever and ever. And I think you're always going to have that. And, you know, we have immigration problems that lead to a lot of those things, and there's a
Sure.
drug problem, and so my work's never going away. So,
Unfortunately.
Yeah.
I enjoy it, but it's tragic. I mean, I tried a lot of cases as a prosecutor, and I've maintained friendships with a lot of the victims of those cases. And, I've seen the effects of those types of crimes.
You mentioned that as a judge, you had to, or you have to rule based on the law, whether you like the law or not. So I want to give you an opportunity.
Okay.
What laws have you found to just be a real problem that you would like to have changed, and how do you recommend they be changed?
I was going to tell you the laws I agree with, that the courts are unconstitutional, but, well, the only way to change them is, depending on what level you are, a judge or a lawyer. At my level, as a judge, my role is to follow the law. The only way to get the law changed is to have the legislature change it.
Right.
You just go to them and say, "Look, you have a problem here." I don't know of any particular law. I mean, when I said that, I was thinking about laws that I had to follow that were not politically popular, but pretty clear.
Well, that's fine. Let me shift then to a different
Okay.
question. You know, the Supreme Court ruled that they discovered in the U.S. Constitution the right for same-sex marriage.
Mhm.
Now, what I saw a problem with that was they created this new right,
Right.
but lacking was any accompanying legislative instructions at the state and local level as to how to proceed with that. And we had our state attorney say, oh, you've got to issue the licenses. But there's a lot behind
When you
that.
say state attorney, were you talking about?
I'm sorry,
Paxton
the,
or
um,
DA?
Attorney General, the General, yeah,
Paxton?
Attorney General,
Okay.
yeah. And so the problem was, if you're at the local level and you're responsible for issuing the licenses, there's nothing in the legislation to have, it's a new thing, not an extension.
Sure.
So how should that, was that handled properly, or how should that have been handled at the state level? I mean, if I were a local clerk, I'd feel justified in saying, I recognize what the Supreme Court did, but I need our legislature to pass legislation to provide for that new right. Would that have been?
My recollection is when the U.S. Supreme Court issued their ruling, I think from the highest levels of the state, they were telling clerks, you don't have to do anything, and just ignore it. That brings with it its own set of problems, because although the Supreme Court doesn't have any power to put anybody in jail, they have at least contempt powers. But, you know, it filters down that way. I do think once the U.S. Supreme Court issued that decision, like it or not, it became the law of the land. And state authorities should have recognized that and at least provided some guidance on how those matters should be resolved. And what clerks should do, quickly opposed to that.
Well, not only that, there's the forms, and there's
Everything.
code there
It's-
now as to
yeah.
what to do with a regular marriage, so.
Well, I mean,
That's
now
that
it's,
was lacking.
now it's, you have regular marriage, you have a gay marriage, you have domestic partners, my wife doesn't
Yeah.
believe benefits.
Yeah.
It's a total mess.
Yeah.
And so basically what the Supreme Court did was create this new right that has never existed.
Yeah.
And they didn't offer any suggestions on how to implement it.
Right.
To 50 states, they were scratching their heads saying, wait a minute, what do we do here? And that really fell on at least the state authorities to decide, okay, what are we going to do with this, and how are we going to implement it, and educate elected officials on how to deal with it. I'm mindful of the fact that some officials just said, look, this is philosophically opposed to my beliefs,
Sure.
and I don't want to do it. Some judges stepped up to the plate and did it because they felt like they had to. I just don't do weddings, so it made it safe for me. I've been asked to do them, and I'm like, I don't do weddings. I don't take money for weddings. I don't do weddings, and it's not consistent with my religious beliefs. I like you, I respect you, but there's some things I just don't feel comfortable doing.
Isn't that a states' rights issue though, more than the Supreme? Where does the Supreme Court have the authority to rule on it to begin with?
Therein lies the disagreement with all political parties, just like, you know, abortion.
Right, and they didn't have that right either.
Right, yeah, well, you're preaching to the choir.
And they can't
Other than, I can't say too much about what I think, but yeah, I'm a conservative Republican, so, you know, I thought when the Supreme Court came out and said, you know, we're gonna draw a bright line on the age of executing somebody, regardless of what they've done, and we'll recognize international law in order to implement that. I'm like, well, where do you get that?
Exactly.
Or, you know, one of the most confusing areas we're dealing with right now is they're saying, well, you can't execute somebody who's mentally retarded. The problem with that is how do you define mental retardation? They don't
Yeah.
provide us any of those
The
standards.
court can't do that,
We are
right.
like a moving target for them. We've had, you know, the most high-profile case was out of the Harris County area. And I'm still involved as a visiting judge, even though I'm on the Court of Criminal Appeals, with a case I was assigned in 2011. The guy's been on death row since 1992 because the Supreme Court has repeatedly changed their definition and version of mental retardation. So it's like the guy's got more lives than a cat. He may outlive me. So yeah, I disagree with some of the stuff that they come up with, and that's all I can do.
You have to live
You
with
know,
it.
you know, some of it I just have to follow.
We're short on time. You said you had a quick,
No, I have softball questions. Do you have a better question?
no, but,
We're out of time
we're in
anyway.
we're less than 5 till, maybe we ought to wrap it up.
I don't need a wrap-up speech other
Okay.
than, do you have a quick question?
Well, I'm just gonna ask more about the visiting judge. Did you say you do visiting judgeships now?
You know, I had 5 cases when I ended my visiting judge career, because that's how I was making my living, and it ran up right up to the time I was elected. And they were complex cases that required a lot of writing. I had already conducted all the hearings, and I agreed, rather than bring a new visiting judge in, because I was recused on those cases at the court, that I would just keep those and make it easy for everybody. The state's getting a free judge on those cases. I have nothing to do with them at the high court, and.
So is that a part-time job for some judges?
Is it part-time? It can be part-time or full-time.
Well, that might be practicing law, right?
Yeah.
No.
Oh,
If
can't
you
be
become a
practicing.
visiting judge, you sign an affidavit that states you will not become an attorney of record for any cases in the state of Texas.
I see.
And if you should not keep your seat here, is that something you do, or do you have another plan?
I've got like 2 or 3 plans. I always try to stay one step ahead of whatever I'm involved in, so I've been very fortunate in my career, even when things have not turned out like I wanted. I appreciate you having me come and answer the questions. If you can reach me via email if there's any questions that you have that I might be able to answer. And your endorsement is important to me.
Well, thank you, Judge. Appreciate you
Thank
coming
you.
in.
Appreciate you coming.
All right.